I know we have a great presentation today and there's a lot of information, so I don't want to hold back. I'm going to go ahead and get started with the general housekeeping. My name is Marla Moore. I am the president of the ACEDS OC chapter. Welcome to our last session of our 2021 summer refresher. Fantastic program today, but want to go over some housekeeping items really quickly. First of all, we are being recorded, and this will be available on the ACEDS website on demand. For those of you seeking CLE, you will be sent the information in the forms by Monday or Tuesday at the very latest from the Orange County chapter. If you have any questions for our panelists during the presentation, please DM me directly. I'm under general questions -Marla, and I will be putting that information in there in the chat for people. If you are on like I said, with CLE also, please make sure your first and last name is listed because I'm also keeping tabs for the CLE. I believe that is all of our housekeeping, and I am going to turn this over to our Vice President of the Orange County chapter, Grady Glover. Go for it, Mr. Glover.
Thank you, Marla, and good morning, everybody, and welcome, as Marla said, to our session 6 of our second annual 2021 summer refresher for eDiscovery professionals, attorneys, paralegal support staff, and everybody here in Southern California and all across the country. We are happy to be joined this morning by some very esteemed speakers. And I think if I can do this right, although I'm not seeing the button, Marla, to share my screen, do I have to do anything else? And you're muted.
I made you co-host a while ago.
Oh, did you? Okay, perfect. Is it one of the buttons at the bottom? I still don't see it for sharing.
At the bottom, green share screen.
Oh, green. Ha, just kidding. All right, so let's see. Let me get that started. I apologize for the delay. Here we go. All right, and assuming everybody can see my screen now. Let's get that going. Perfect. Okay, get rid of these other things that I don't want. Clearly not all ready to go, but anyway, we'll get started. So session 6 is a different session because a lot of times what happens is there are presentations they're put on for a national audience, and essentially what happens is they cover eDiscovery under the Federal Rules of Civil Procedure. And that's fantastic if you're practicing in federal court, very important information. However, for those of us that live and work in California, sometimes we have cases in California state court. And that's really what the focus is going to be on today, is how to handle eDiscovery in California state court, especially as it relates to some recent changes, which all were effective on January 1st, 2020. So without any further ado, let's jump into the first slide. And I wanted to say again, thank you for joining us this morning, Gareth and Joy. So on January 1st, 2020, there were some changes to the Code of Civil Procedure, which is the California code that we all deal with for civil litigation. And first, I want to go over what some other people said. So there were some articles posted on the internet. You can find them with Google if you'd like, but one was posted on the McGuire Woods website, and the title of that article was New Discovery Rule May Be a Nightmare for Litigants. Shepard Mullen's team posted an article, Cost and Burden of Discovery for California Employers Will Likely Increase. And the third one was DLA Piper, New California Laws Make Potentially Costly Changes to Civil eDiscovery Act, which is where we find the Civil Discovery Act inside the CCP. So a little bit of doom and gloom there, and there were a couple of changes as a part of that. The first one was a result of Senate Bill 370, and the title of that was an act to amend Section 2031-280 of the CCP, and essentially the preamble talks about the purpose of the Civil Discovery Act and how we all exchange information to get the best result. And this bill would eliminate the option to produce documents as they are kept in the usual course of business thereby requiring all documents or category documents produced to be identified with the demand. So that's a big change, because even under the federal rules, typically you can produce documents as they're kept in the usual course. But now under California rules, that's no longer adequate, and you have to tie the documents back to the requests. And that's the first change. So if we look at, and then, sorry, the other change was Senate Bill 17. And this one modified 2 sections of the CCP, both 2016-090 and 2023-050, or added them really. And I lost that slide, but we'll come back to it. Let's go back to Senate Bill 370. We're going to start with that one and the changes to 2031-280A. So the old version said, again, any documents produced shall either be produced as they're kept in the usual course or be organized and labeled to correspond with the categories and the demands. Now they've changed the language, and it says any documents or category documents produced in response to a demand for inspection, production, or sampling shall be identified with a specific request number to which the documents respond. And that's a big change. And I think that that is essentially 180 degrees different than it was before, and has really created some new challenges, but it also created some questions. And so, some of the questions that were created in my mind and with some of the other attorneys that I work with and practitioners is, first of all, when is that effective? And of course, it was effective on January 1st, 2020. But what we know in California is that when there's a change to the CCP, typically that's going to apply to all active cases, regardless of when that case was filed and regardless of the status of the case. And that comes from case law from 1985. So with that in mind, that, okay, if I'm midstream on January 1st, 2020, I'm in the middle of a litigation, I've got some documents out the door, I've got some additional things to respond to, it changes some things. Yet there wasn't any guidance for how to handle ongoing cases or larger or more complex matters or issues that might come up in those matters. So for me, the first question that this really begged was, does providing the base numbers of your documents in the written responses to those requests for production, does that comply? And if so, when is there a duty to provide base numbers of previously produced identified documents in subsequent requests, for example, and or when is there a duty to supplement your prior responses? And I don't know that we have an answer to that question, but I don't want to speak forever all by myself. So I wanted to give either Gareth or Joy an opportunity to chime in at this point and see if they had anything to add.
Yeah, Grady, I think it's a really interesting issue because while California law provides that the provision would apply to cases that are already in process, so you don't get grandfathered or grandparented in if it's a pending case. Does it apply retroactively to the productions that you've already made? And I think that is unclear. And I think that this is something that will likely be litigated a fair amount, particularly where doing so would be really burdensome. And I think, you've got some examples of some decisions that have already come out. And I think that although that may give us some guidance, I think since it's not, binding appellate law, you could see things all over the place. And if I were in a situation where I had made, really, voluminous productions already, doing that would be very, very burdensome, and would likely, seek to be exempted from doing it from the prior productions, while understanding that going forward we would need to do it. And so, and if necessary, would litigate that before the court.
And
Certainly. Sorry, Joy, go ahead.
No, I was going to say to that end, I mean, it's both parties discussing it, right, and coming to an agreement on how they're going to handle it. And I think that in itself is a challenge with both sides discussing the issues, because some people try to either bury their heads in the sand, or they both take an attitude like, if you don't ask, I won't ask, right? I think it's a very interesting dynamic that it's been since 2006, like back in the day with the federal rules changing, that there is a time of transition where people don't understand that these rules could be a sword or a shield for them, and yet sometimes they just decide to ignore it. So it's very interesting to see what the practical, what's going to come out in the next few months, because you're seeing both in the old days, both parties ignoring it, or it being a Samson and David, is it the, oh my gosh, now you have Goliath, David and Goliath. It's just,
David and Goliath, yeah.
Yeah, David and Goliath. But that situation where when there is a David and they see this, they're going to use it. But then when it's two Goliaths, realizing that this is going to be very costly, do they move forward? So I think it's interesting on the strategy behind, or the ignorance behind using it. So again, I'm just glad we're talking about it. So
yeah, I think that's an excellent point, because I think where it would be burdensome for both sides, you're much more likely to get an agreement. And then when it's asymmetrical litigation, such as a lot of class action litigation, and the burden is really only on one side, and the burden can be a sword, then yeah, that's where you're likely to get into a dispute.
No, thank you, Gareth. Great point, Joy. I appreciate that. And to that point, another question for me is, does a motion to compel lie when a party fails to comply by designating which request each document or category is responsive to? Is that sufficient? So in other words, if as the producing or the responding party, I give you all the documents, right? And I say that these documents are all responsive to requests 1 through 4, but I don't have any documents necessarily responsive to a couple of the other requests, but the other side thinks they might be. Is that a situation where there's a motion to compel because of a designation issue, even though they've produced the documents? Or how exactly, are you going to be forced to do it? I think the motion to compel is probably the correct avenue. And I think we have some tentative rulings on California cases on motions to compel, which would, answer that for us. And the answer may be yes. And depending on how egregious the failure to designate is. And then the third question in my mind went away, but that's all right, which is really essentially, how do you deal with prior productions? And I think to your point, and I think one of our key takeaways today, and to spoil this a little bit early, is going to be, engage in that meet and confer process early and start to work these things out, because it's certainly no good to be facing a motion to compel and then, be like, well, we didn't really want to designate, because you may be a little bit late in the game at that point. Plus, there's some incentives now to respond to some of this discovery earlier than later, in terms of new sanctions and stuff. But so if we jump into one of the first, again, not a lot of published binding case law on these on these changes yet. I did find one case, and in that case, which I don't have in the slides, the judge made him go all the way back to 2017 and relabel everything. And I thought that was an outlier, so I didn't use it as an example. But anyway, here's a tentative. Yeah, go ahead.
Yeah, so I think one of the really interesting things here is, it seems first of all, it seems really clear that if you don't identify the requests in your for the documents, you're not in compliance, and a motion to compel would lie. But what if the receiving party reviews the documents and believes that the designations are inaccurate? Then what? And how does that play out?
Yeah, I was just going to say that it, for us, like from the practical standpoint, I think either one, because we do know, when we do a document review, you're going to split it usually into 2 passes, right? The first pass is usually trying to separate again, I'm really bad with my quotes this morning. I must need more coffee, but the wheat from the chaff, right? Really what is responsive versus what is not relevant to the case or whatever, because we over collect, because people don't have time for us to take the time to research their mailboxes prior to review. But I think that when we do first pass review, we're looking for usually, non-responsive or responsive. We ask them to try and identify potentially privileged, and then we try to ask them to do issues. Now, I think it's interesting to design it, maybe, Gareth, when we think about these issues, to be more about responses. And I don't know if maybe you convert, the actual response numbers to categories of issues, so that kind of can relay back. But the second pass is usually done by the case team. So I would think that our productions are going to get smaller if we're going to have to do this. There's not going to be this, let's just run search terms and just dump them on it and then just give it to them faster. So I think there's going to be, you want quality or you want quantity. I think that's going to be a question in that iron triangle right now.
Yeah, I completely agree. I think this appears to be largely directed at what's maybe unfairly known as the document dump. There are certainly situations where, rather than incur the expense of reviewing every document that hits the search terms, clients are in a situation where, either because of timing or because of the cost, and they're not particularly concerned about irrelevant information going out, that they're willing to run the search terms and produce all the hits, maybe combined with a clawback provision so that they can get back anything that was privileged, or they've used like search terms to try to identify, or TAR to try to identify documents that may be privileged and withhold them. But it really kind of impacts your ability to do that. And so it's probably good news for the managed review industry. And I think, though, in large document cases, we're getting more and more accustomed to using technology-assisted review or predictive coding, whatever you want to call it. It becomes a lot more difficult where you're training the algorithm to identify, whether a document's responsive to individual, numerous requests versus just, is it generally responsive and relevant or not?
Absolutely. And to that point, we've got some recent tentative rulings, and these are all from rulings.law, an online database of California tentative decisions. So thank you for that. And this first one is from July 8th, 2020. It's from LA Superior Court, the Honorable Elaine Loop presiding, and her tentative ruling on a motion to compel in Serrano v. Crown Energy, where she says it's unclear if defendant has provided all responsive documents, as defendant has not identified the specific request number to which the documents respond. And then she quotes the new section 2031-280A. Accordingly, defendant is ordered to provide code compliant responses for the documents produced by identifying the specific request number to which each document responds. Now, the one thing that I think is interesting is if you really read her ruling, I think she's got it right, and she probably got it right from the statute, but identifying the specific request number to which each document responds, as opposed to identifying each document which respond as responsive to each request number. And I get that those are essentially the same thing, but there's different ways to go about it. And that's my point for this one. And then if we look at another one, we've got another LA Superior tentative, this one from presiding Judge Kevin Brazil. And he said the materials provided by plaintiff included the amended responses, do not identify which documents are responsive to which RFP as required. And then he quotes the new section. Notably, plaintiff's earlier discovery responses also exhibited this defect as discussed in the prior order, compelling. The court therefore grants a motion to compel, where here, like her past discovery responses, they don't comply with the act. And he went on to award sanctions jointly and severally against the plaintiff and their counsel, which of course means everybody has to pay. And although he didn't give him the new sanction, but he did give him the traditional you lost a discovery motion, so here's the cost of bringing the motion sanction. And then let's see, I think we've got one or two more of these. This one is from Orange County Superior Court, Judge Kirk Nakamura, and he said she instead argues that, and this was interesting sidebar. This is an argument that was made early in one of the articles that was published right around the time of this change that said they weren't sure how judges would harmonize 2023-010C with the new provision 2020, whatever, the one we're talking about, 2031-280A, because 2023-010C is about protecting parties from overly burdensome discovery and abuses of the discovery process. And so in theory, if you had one party send out 500 requests for production in their very first set, that may or may not be egregious and overly burdensome. Here, the judge wasn't buying that argument though, and said, she argues that somehow the protective clause of 2023-010C may trump the new document identification requirement. But Judge Nakamura was not persuaded and said that that other section merely defines employing a discovery method in a manner or extent that causes unwanted annoyance, embarrassment, oppression, or undue burden and expense as a discovery abuse. And he doesn't see how you harmonize those together and get out of your obligations under 2031-280A. I think that he tacked hard to the left here, and he probably might have split the baby, except that their argument wasn't persuasive, right? So if they used, if it was truly burdensome, I guess is my point, or they'd proffered some evidence about the burden or expense, they might have gotten further. And I don't know that they did, but I don't think that they did. And I think they just tried to say, look, this is crazy and we should be protected from that. And he said, no, this is a new thing you got to do.
Yeah, well, I think what this really tells you is if it's going to be really burdensome to do this, you don't just not do it and hope you get away with it, right? And then be able to claim, well, we didn't do it because their requests, were too burdensome in the first place. You have to challenge the requests up front. And one of the arguments that you could make is, well, not only are these, overly broad and call for us to produce irrelevant or marginally, not helpful documents, but also it's going to be even more burdensome because of the volume and the fact that we're going to have to identify the request every document is responsive to. Because it sounds like here what the litigant was trying to say was, well, we didn't have to do it because the requests were too burdensome in the first place, and it obviously didn't fly.
Yeah, so what she did was she read the article, but she just skimmed it. And she didn't get down to the meat of it before she wrote her motion or her response, I guess. Yeah. But no, I think that's a great point. We've got one or two more, I don't remember, but we'll see. This one's from San Diego because we love San Diego also. Judge Kenneth Medell, and he says that the party argues because it previously produced documents, it has no obligation to comply with the code regarding its current production, and that the requirements of 2031-280A only apply to prospective production, which we've already talked about. And accordingly, they already produced these documents and don't have to link them with the new requests. Judge Medell was not buying that, said that the language of the statute does not support your theory. Given the plain language, your responses are inadequate. The code requires identification. I think that's a simple, I really like when judges do that 4-word sentence. The code requires identification. If already produced, they should be identified with a base stamp number. So what I like here is that the court's got an idea of how to do this. And hey, if you don't, here's a method that's going to get you through, right? And so you can identify the prior documents with base stamp number in your supplemental responses. So I like that. And then in this same opinion, he covers, it's awesome. He also argues against one of the early articles that was written that said that there was somehow a difference in California law between the definition of ESI or electronically stored information and a document under in the CCP. And while I think that may or may not be true, what Judge Medell said was, yep, except that documents under Evidence Code 250 is going to incorporate ESI. Therefore, the argument that ESI somehow gets treated differently than documents under this new section is baloney. And there's no reason to exclude your ESI from the requirements of 2031-280A. And therefore, you know, they had to go ahead and comply with his ruling.
I have a question for Joy on this. So let's say you're in this situation, you've produced a lot of documents already, you haven't identified in your coding which requests the documents are responsive to. Do you have to go back and re-review all these documents all over again?
Well, personally, I probably would use active learning or some kind of AI. And if you had a core set that you already identified as some issues or to a number, then I would actually try and train the system to see if it can preliminary identify it. I also would probably go back, as I mentioned, usually the reviews have some issue codes and kind of buckets, create buckets for the attorneys. I do think that this, if you can really look, I think this is an opportunity for paralegals too, to really take a look at the document review memo early on and really trying to see where those response numbers fit. So at least you have some way of teasing that out. We can actually, from a technology standpoint, design within an issue, have request numbers as be a nested tag underneath it. So I think that's one thing. I wondered at some point if, as we're going through a review, because maybe they're focused on one issue and reviewing for that on a second level, just when you deliver, I'm wondering if we can just give overlays or give, instead of putting it in a document with Bates numbers, actually including it in the production as a field. When we produce documents, that field could be updated through time and during iterations. So I do think that there's a way to make this more efficient using technology. And I think that with the pricing, the way things are coming, AI is included with a lot of new review tools. So I think that, again, as paralegals and attorneys and associates who are trying to convince the partners of why it's important to use technology, it actually may be more cost effective to do it with some AI and leverage the knowledge that's already in there. I've seen people find things that they didn't see before because of AI. So I think it's another way to hopefully get an ROI on that investment is to get attorneys better data faster. So they could issue code it.
Yeah, that said, I do think that Gareth brought up the great challenge earlier, which is once you get that granular of RFP numbers, that it becomes harder and harder for the AI to be comprehensive and do all the work for you, which I think is what we'd all love, is if the AI would just do the work for us. But you know, so for our cases, for example, I'm as soon as we get sets of RFPs, then I'm creating complete sets of RFP tags because we want to start that from minute one. Because we know that we have to do it downstream. And so we're trying to front load it by at least doing the RFP tags in there as we do our first pass.
Yeah, and I was going to say, I don't know, Gareth, in regards to like doing custodian interviews when we do them early on, when we're doing legal holds and we're following up with people, I think there's a lot of information left on the table from those early, because by the time we're doing discovery, it could be a year, 2 years, right, between that time of the legal hold when it was first issued. But going back and really working with your custodians and trying to define these issues in response, I think it's, I don't know, sometimes I feel there's a disconnect between document review as its own individual exercise and then the actual substantive merits is a different team. It's really the same team, but it just feels like it's two different projects to them instead of one, you know, consistent goal at the end.
Yeah, one big project with subparts maybe, right? Absolutely. And let's see if we have any more. I think there's one or two more here. Judge Lee from Orange County Superior Court said that the supplemental responses aren't verified and the supplemental response to number 16 does not identify the responsive documents as required by Code of 2031-280A. Thus, the court grants a motion as to these remaining issues, defendants to serve verified further responses to 16 and serve a verification of the supplemental responses within 30 days. And what I like about this ruling is, for me, it brings up the fact that if you're, I look at this as there's essentially two ways to do this. You're either going to put base numbers of responsive documents into your responses, or you're going to include it with the metadata, as you suggested earlier, Joy, which I think personally is the better method. I think one of this also brings up a downside to the method of putting base numbers into your responses, is that your responses then have to be verified, right? And every time you want to add new numbers and you want to add new documents, you're going to go back to the client. And really, I mean, if you're doing it correctly, it's here's the new documents that we're proffering, right, as responsive to this question, please sign. That seems onerous. And I think that the opposite or the other method of producing the coding with what document ties to what response, and then continuing to supplement your productions, even if you have to add, you know, coding for documents previously produced, which are now responsive to supplemental requests, but that's all in the metadata that you produce with a small supplemental production for, you know, adding metadata to documents you've already produced. You don't have to supplement. And I think, you don't have to supplement your responses, written responses necessarily, and you certainly don't have to get verifications for that. So I'm not saying that you don't want to be truthful. What I'm saying is that getting verifications is onerous, and actually having your clients verify what you're sending out the door is difficult. And so this is a method to still be code compliant and maybe not have to do that extra step. Those are my thoughts here. Any thoughts on that?
Yeah, well, also, I mean, query whether someone really can give a verification without having reviewed every one of those documents and the request.
Right, and that's a better way of saying what I was trying to say, which is that it's hard to do, right? It's hard to literally, you know, I can give a verification to a client with written responses, read the responses, please sign the verification, very straightforward. The opposite is true, I think, with trying to get them to verify RFP responses with document base numbers in them. You know, you'd have to put the documents in front of them also. And it just, at the very least, it'd be more work, and it may create opportunities for some mistakes. I'm not sure, but
from a technical standpoint, I think this is interesting, because if we would give license accounts access to the data through the database to their clients, this is kind of an interesting way to probably get them to understand why we use databases, why this is an important and necessary cost. In regards to this is now a way that, again, we can get a larger ROI on the databases we already have, maybe making and giving access to these documents to our clients in small sets that they can flip through quickly or whatever. Anyway, just the technology side of my head going.
No, absolutely. I do like tools where it's review platforms where it's possible to give segregated documents to certain people, especially when there's not per user charges or things like that, or they have unlimited users in your subscription model, whatever. And I do think that it's our fiduciary duty to the client to try and get them to do as much of the stuff as they can. And, you know, to your point about, oh, we don't have time to go through the data with them, and so we over collect. That's 100% accurate, and what happens every time. And I think that also really drives up the cost for them, which they may or may not understand. And you know, look, maybe their time is far more valuable than the attorney time that we're going to charge them for to do that. And maybe it's not, and maybe they can't afford it. I'm not sure, but just lots of different information and lots of different things to think about with these changes. All right. How are we doing on time? I forgot my watch. There we are. We're good. Okay, thank you. So,
Grady, we do have a question, if you don't mind.
Yeah, no, let's do it.
Okay, how do you accomplish this without using 1,000 issue tags?
Well, we've got a best practice slide coming up, and I think that there's a way to push back initially. So the short answer to the question is, that question assumes that the other side has basically sent you 1,000 requests, right? Or has sent you 800 requests and you have 200 issue tags also, or something like that. And I think that one of the things that we're going to go over right here in best practices on the slide is working with the other side early to seek an order, establishing a joint protocol which covers scope, methodologies, production standards, clawbacks, privilege logs, confidentiality, and these 2031 288 designations, right? So we want to cover all this stuff. We want to cover it early. We want to really know what we're going to do before we start to do it. And I think this is a big part of that. But even if we have this, the other side could still shoot off 1,000 requests at you. So I think point 2 here is the direct answer to your question, which you object immediately and essentially refuse to respond further to voluminous numbers or duplicative RFPs as oppressive, unduly burdensome, and overly expensive under 2023, that same section, and consider seeking a protective order, right? So if you object and they say, we're not going to do anything about it, then you take the proactive step of going into the court and asking for protection from your crazy opponent. If the propounding party is not willing to reduce the number of requests proportionally, and in LA County, we end up requesting informal discovery conferences very often. Many times our judges require them, but it's nice, especially over Zoom, where we don't have to go running in. You can get judicial guidance quickly for your issue without having to brief it, meet and confer, write your motion, wait for a hearing date, all of that. So the answer is you have to object. And sometimes there's going to be cases where 800 requests are absolutely potentially proportional to the needs of the case. You've got 50 parties, in some giant construction defect or some other multi-party case where there's a lot of stuff to cover, right? In a lot of the litigation that most of us participate in, that's probably an egregious number. And I think the whole purpose of this is to meet and confer early, and maybe when you're establishing that joint ESI protocol and you're talking about the 2031 288 designations, you point out the fact that, the requirement to designate really makes it more difficult to respond to 1,000 requests. So we're not going to do that. So we need you to really propound succinct requests or categories of requests. And then we're going to play ball with you and we're going to identify the documents. And if you do anything else, we're just going to go in. So those are a couple ideas. Any other ideas or any other answers to that question that I missed?
Well, it just brings to mind for me that I think that now you have to have a database of all the requests so that you can start to look at them. Because if it is getting duplicative, I mean, how are you going to push back if you're just reacting and it's just another request and you're running around? So I think, again, opportunity for paralegals and associates to really play an important role in catching those things. Yeah, if you get thousands, I mentioned it before, but organizing your organizing your tags in the review database, you can nest things. So I really do think, and Gareth and Grady, I don't know about like thinking about the issues or the topics, because I think that's what they're getting at, right? They're trying to look for documents that support this kind of issue. So maybe the concept when reviewers are looking at, they see an overly broad, like, oh, this deals with harassment, and then specifically what kind of harassment due to some or whatever, but documents. So I think being smart about how you organize your strategy in responding and identifying these documents for production during review is important. I think we just don't take that time though. I really do feel like we repurpose previous review memos. They just copy and paste some background, and this is a standard first pass review. They don't leverage those attorneys who are spending a lot of money on, who are barred. And I mean, these are people in this economy right now, what's going on. There are a lot of really great subject matter experts who are sitting on first pass review, and we're not leveraging them. And so I think this is an opportunity in California anyway to for the case teams to think about how they can really exploit that first pass and get more data out of it.
Yeah, and I can guarantee you that the partners on the case and probably a lot of the associates are not thinking about these issues. And so, it's definitely a place where, paralegals can add huge value to make sure that, that the case team is made aware of the impact of these rules later, downstream, and that it needs to be dealt with up front, and this is how you do it.
Grady, we have a couple more questions. I'm sorry, that came in. That
no, go ahead.
Christian Castro wanted to know what he says prior to commencing discovery. Does he mean during the meet and confer?
Well, I mean, so under California law, you're not really required to meet and confer on these issues until late in the game. And that's a few days before the initial CMC, I don't know, 10, 15 days. And that's really late in the process because you only have to wait 30 days as a plaintiff to start propounding discovery. And your CMC is not going to be for 6-9 months. And so you could be well into a bunch of discovery fights long before you whip out your CMC statement and realize that you're supposed to meet and confer before you can check the box on the statement. And so, no, I think it would be a mistake to wait until you're required to meet and confer under California law. I think the best practice would be to essentially, as soon as the pleadings are at issue, or as soon as anybody decides, you get some early discovery from somebody or something, you need to engage the other side in talking about an ESI protocol that covers all the things we talked about. And if you wait until when it's required under California law, you're going to be way behind. You probably have already been to court a couple of times on some discovery issues. And you're going to be working these issues out piecemeal and not all at once in a way that's comprehensive and covers you. And, you may, for example, if you do the piecemeal, you might do parts of these things, but forget the clawback part and then produce a privileged document. And then they want to fight with you about it. And you're hosed because now you've got to go down this whole road and fight with them about it instead of just relying on your prior protocol that no, just send it back. And with that said, I think there might be one or more additional best practices. So we covered this one, which is produce the identifications with the documents and the metadata and not with the responses, which have to be verified when possible. And supplement your identifications in lieu of supplementing your written responses, if possible, as additional RPs are propounded where previously produced documents are responsive. So essentially, you can put that coding in the load file and you don't have to necessarily supplement your written responses and pull out 1,000 Bates numbers and put it in there. Let's see, I think we have one more. And this dovetails nicely, although there's one more slide before we get there. But consider the new procedures of 2016-090 early on, because that's another way to reduce costs. We'll cover more about that in a second. Suggested workflows. Again, identify the documents responsive to each request using tags for each party and set an RFP number. So multi-party case, you might have multiple sets of tags for each party. If they've got different sets of RFPs and it's not continuously numbered, then you might have set 1 through 100, set 2, 1 through 100, etc. Create an RFP tag for each, and to Joy's point, nest those by subjects if you can, because that's a really great way to do it. Create an RFP tag for each request and apply it during the review, so you're not coming back around on the backside having to do it after the fact. Excuse me. Create sets of RFP tags. Yeah, I think we covered that. And the first one, import other parties' RFP tags into the workspace. This one we haven't talked about, but if you've established a protocol, it says you're all going to just tag docs, which would be ideal. Then as the other parties designate documents, then you're going to import those tags into your workspace so that you can see the documents that they've coded as responsive to your requests or co-defendant or a different party. And then produce the RFP tags as a custom field for each document with the metadata in the load file. Excuse me, sorry. So that's essentially that first SB 370 and the changes to that. Are there any other questions before we jump to the next one, Marla? Hearing none, we'll just move on. So
no, I'm sorry. I was on mute. I apologize.
That's okay.
For that. Multitasking over here. First of all, Robin Greenberg said it's a genius idea about putting the coding in the load file. And then Eric Cook, and I know we're kind of coming up short on time, but when commencing discovery, how do you know what you want when you don't necessarily really know what the other side has?
Well, that's why you establish a protocol, right? So you're going to propound a bunch of discovery to try and figure out what they have. But you want to have a broad enough protocol so that you're going to get back what you want in the format that you want, and be able to tie what they send you back to your requests. Any other comments on that, Gareth?
Yeah, sorry about that, Grady. You had answered it after I had typed it in.
Oh, okay, no problem.
So thank you.
Perfect. So
that's it for right now.
Good. On to the second change, which is really two changes in one bill. So we added two sections to the CCP, 2016-090 and 2023-050. And that was Senate Bill 17, which seeks to curb the abuse of important pretrial stage of discovery. Under current law, the process is being abused. The abuse works to delay and dramatically increase the costs, irrespective of the merits. And this is interesting. Senate Bill 17 seeks to reduce this abuse by changing the current suggested sanction to a mandatory minimum sanction imposed on lawyers that engage in the abuse of the discovery process. And they may, and you can opt into the optional discovery provisions of 2016-090, which is that last sentence. So the purpose of this, again, we're trying to cut down on the abuse, maybe cut down on the cost, add a minimum sanction. When the bill was written, it was 1,000, but it was reduced in committee at some point to 250, which I thought was an interesting choice. But so what happens? Senate Bill 17, upon order of the court following a stip by all parties, requires a party to participate in a Rule 26 analog. So you've got 45 days to provide the other parties an initial disclosure that includes certain information. And also, we've got this second part of 2023-050, which adds a $250 sanction, which may be reportable to the state bar. And that is the significance of this sanction. Whereas most discovery sanctions are exempted from reportability, this is specifically up to the judge's discretion of whether or not you will be forced to report the $250 sanction to the state bar, which I think would be a bad thing. That's what that is, within 30 days. And of course, there's an opt-out. The court can excuse the imposition of the sanction, but it has to make written findings to do so according to the statute. So let's talk about, there's supposed to be a presumption that the liable party should be forced to pay sanctions to the prevailing party. And I don't have the year of this decision, which is unfortunate, because to Gareth's point earlier, or maybe from one of our talks before, in the old days, it was kind of automatic when you went in that the losing party in a discovery motion would get, essentially have to pay the cost for the other side to bring the motion as a sanction. But that has slowly gone away. And isn't that right, Mr. Evans?
Yeah, I mean, I think, at least in my experience, you rarely see that these days. And I think, one thing we've increasingly seen, I think probably many of us or all of us on the call on the webinar have experienced where it's no longer just making your requests in a set of RFPs that then, almost automatically, and I've been in cases like this where I've been on the plaintiff's side, and then the whole process becomes first the defendants object and refuse to produce documents that are clearly relevant to the case and are appropriately asked for, then you have to bring a motion to compel. And then that gets drawn out for another couple of months after you've already had about a month on waiting for the responses to the document request. In big cases where there's a lot of discovery disputes, you might have a discovery master, so that it gets litigated before the discovery master. The discovery master rules in your favor, and then there's an appeal to the superior court judge. And suddenly, it's taking you, 5 months or so to, or 6 months to get the documents that you really should have gotten, within 45 days or so. So I think this is really kind of directed at, what has increasingly occurred where, even arguments that really aren't being made in good faith and aren't reasonable, is trying to put some focus on addressing that and deterring it. I think right now, judges are very, very reluctant to sanction or to shift costs. And it only occurs where the positions are just downright frivolous and just, really egregious abuse. And I think this is just directed, especially with the low $250 sanction amount. I think that's also meant to make it easier for judges to do and to send a message with, well, I'm going to give you, a $250 sanction. If it was $1,000, the judge might not be as willing to do it.
No, that's a great point. And with that, of course, I put the slides in backwards order. So let's talk about, instead of the $250 sanction, let's talk about the first part of this change, which is the new 2016-090 provision, our new Rule 26 analog, I'm calling it. And of course, this is a voluntary provision. So the first part of this section says that the following shall only apply upon an order of the court following stipulation by all parties. So again, that early conference that we're talking about where you want to establish ESI protocols, one of the things you want to proffer potentially, if it makes sense for your case, would be, let's follow the new voluntary provisions of 2016-090, which means that essentially now we're going to do a Rule 26 dump 45 days after the court signs our stip. And that Rule 26 dump is going to have the names and addresses and telephone numbers and email addresses of everybody that's going to have, it's likely to have discoverable information, the subject of that information, with the exception of things that you would only use for impeachment, a copy or description by category and location of documents and ESI and tangible things that the disclosing party has in its possession, an agreement, your insurance company policies, and potentially any judgments that might affect the case. So this section, again, if it makes sense for your case, or you're a federal practitioner and you're very comfortable with how to practice under Rule 26, and you don't like state court rules, you might want to opt into this because, at least on the surface, it seems like this is an easier and potentially less expensive way to handle these discovery burdens. The second part of the statute says you'll make these initial disclosures based on what you know at the time. And I'd like this part, that you're not excused for making your initial disclosures just because the other side didn't do it or didn't do it sufficiently, or you haven't fully investigated a case. So you don't get out of it. Even if the other side is late or doesn't do it, you can't wait. You got to shoot your discovery or disclosures out the door.
Yeah, what I think is interesting here is that this is something that's it's essentially voluntary and both sides have to agree to it. I'm skeptical that parties will agree to this very often, based on what I see in litigation, but who knows, I may be proven wrong.
I think you're 100% right. I think, where we might see it is with a very litigious party that then gets burned a couple times, and maybe their general counsel is aware of it, or they practice in both state and federal court and they get really burned in state court. And then, their GC is like, why don't we but that may be a pipe dream, and they might not be thinking about any of this stuff, even though as an eDiscovery guy, I'm thinking about it all the time and hoping that everybody else does too.
Yeah, I mean, I think the intention is really good, it's just given the way parties litigate these days, but also with the federal analogy, at least in my own experience, which may not be fully representative, but I tend to see the Rule 26A disclosures in federal court are not particularly robust, shall we say. So, and I think, there is somewhat of a movement in some states to kind of put more teeth, shall we say, into the early disclosure requirements, kind of going, it's like Federal Rule of Civil Procedure 26A, but like, much enforced much more, and much more is required than is currently required under the rule. So it'll be interesting to see where all this goes, both in California and on the federal side.
And
sorry, Joey, go ahead.
I was just gonna say, and I always like to push again for whether you're an associate, young associate, or a paralegal. Again, a great opportunity to learn and work with your partners to understand their, what is their strategy, what's their risk level in regards to, oh yeah, we'll handle that tomorrow, or oh my gosh, because I think I've seen the transition from the federal rules coming in and how people say it doesn't matter, we'll just do the same way we normally do it. But at some point that does turn, that tide turns. So as a paralegal and associate, being there and understanding the obligations and then understanding that specific case, because one, the partners could be busy doing something else and you're watching, and that's again showing your value that, oh my gosh, it's happening now. Okay, yeah, here's what we're going to do. Can you take this on? Can you just start this? I think that's a great, again, opportunity. Or it is a strategy that's part of the chess game here in regards to what they're going to do. It's a great way to understand and get insight to how your attorneys practice. So it's a great way, no matter what, to understand what this new rule is about.
Yeah, and I think the third point to be made there potentially is that, and I don't know if this is the case or not, but my sense is that this may be testing the water a little bit. And even though not a whole lot of litigants opt into it, it may be, foreshadowing of things to come if we continue to have these egregious discovery fights in California state court. The legislature might just say, look, I think we're going to do it a different way now. I don't know.
I think you're right, Grady. I think that this is going to be an iterative process, and this will be changed to become mandatory rather than simply voluntary.
So get ready now. I'm just kidding. But if it makes sense now, it's certainly, there's an opportunity here to save some money as you litigate, because the requirements are slightly different. That said, wow, that flies out of, let's go. The other thing we want to talk about is this new reportable $250 sanction, right? So the other new section of the CCP as part of SB 17 is 2023-050, which says, notwithstanding any other law, and in addition to any other sanctions imposed pursuant to the Discovery Act or the CCP, a court shall impose a $250 sanction payable to the requesting party upon a party, person, or attorney if, upon reviewing a request for sanction made pursuant to 2023-040, the court finds any of the following. They did not respond in good faith through an RFP made under the standard sections. The party produced documents within 7 days before the hearing or the scheduled hearing on the motion to compel. And then the third was, if you fail to meet and confer in writing in a reasonable and good faith attempt to resolve informally any dispute concerning the request. So there's three different things there. And if you do any of them, essentially the court is supposed to automatically slap on that $250 sanction if, while reviewing a request for sanctions made pursuant to the CCP, they find that you did any of those three things. So essentially, it's an add-on sanction. I don't know that you can ask for just the 2023-050 sanctions by themselves. I think, yeah, which wouldn't make any sense anyway, because you want the cost of bringing the motion. But when you bring your motion to compel and you add on, as we all do in due course, the cost of bringing the motion and request for sanctions, now you want to add on another paragraph that asks for this $250 sanction, and you might as well ask that it be reportable. I mean, unless the conduct's not egregious, but if you're writing a motion to compel and you're asking for sanctions, I think you're at that point. So you might want to request that it be reported, or that the judge requires the other side to report it. You might just request the $250 sanction and leave the reportability part kind of as an unwritten request. But it really depends on, you know, how much fighting you're doing with the other side about this stuff. So to your point, the 250 may or may not be easier. But I think it's interesting. And now we have this other thing, which is this reportable sanction to the state bar, and the judge gets to decide whether or not you have to report it. And I think that that gives judges a little bit more teeth. Look, and I think by bringing it down to $250, they may or may not be more inclined to actually use these sanctions. But it's really two-pronged, right? They can apply the $250 sanction, but not make it reportable. They can do neither, or they can do both. And so it'll be interesting to see. I think it's another opportunity for courts to split the baby initially, maybe add the $250, but not make it reportable. But we'll have to see what happens. And so theoretically, the court can only excuse the sanction if it makes these written findings. But of course, they have to have an opportunity, you know, they have to have notice and an opportunity to be heard. And so with all of these things together, we'll just have to see how the courts do it. We do have quickly some tentative rulings on this new sanction. So from LA Superior, the Honorable Stephen Morgan, just a month or two ago in June of 2021, he didn't give any sanctions. No sanctions will be imposed under the standard discovery sanction or the newer, right? So shout out for the reference to the new sanction, which, and then he talks about it, requires the court. Except that in this case, I believe that we have an improper respondent, right? So, however, for the purpose of the statute, there's a rebuttable presumption that if you're self-represented and you're a natural person, so not a corporation, potentially, maybe don't quote me there, but if you're self-represented, I'm not sure what a natural person is, and there's clear and convincing evidence required to overcome the presumption. So if you don't have an attorney, essentially, you're probably not going to get reported to the state bar because it wouldn't do a whole lot for you since you're not an attorney. But and here, essentially, they didn't submit any evidence whether or not the unrepresented plaintiff acted in good faith. So they didn't get the big sanction, they didn't get the $250, and certainly wouldn't have done any good to report that improper person to the state bar, unless of course they're an attorney. But so LA Superior, Judge Holly Fujie, the court denies a plaintiff's request to make a finding of bad faith against Lyft and its attorneys and an award of monetary sanctions to Lowe in the amount of $250. So, and this was August of last year. I don't know that she got this completely right, because I don't think she has to make a finding of bad faith against Lyft. I know they were represented, it says, and their attorneys. But at the end of the day, she didn't impose the sanction, right? So I don't think you're going to do anything about her not imposing a $250 sanction, because it's cost prohibitive to even think about it. That said, she didn't give it. Food for thought. And here we are in Riverside County in view of the totality of circumstances. So they asked for too much money, but she gave them sanctions and reduced it to something reasonable, 8 hours of work. She did criticize them because there was it was like 8 hours each for the high level associate at 665, and then like another 8 hours of partner work. So she reduced that, but she did give him the $250, but she didn't make him report it, right? So, okay, in the context of $3,000, is an extra 250 really anything? Or 39.15? I don't know. Right? Like, does that $250 extra dollars do anything if you're already cutting a check for 3,900? I'm not sure, but we didn't get the sanctions there. And so I would ask for it. But anyway, I think we're almost out of time, 6 minutes over, and we're at our key takeaways for today's presentation. So the first one, right, is that based on these changes, if nothing else changes in your practice, document review and production now could potentially take longer. There's a lot more decisions to make on each document and could be far more costly. In a very small case with 10 requests and 10 documents, that may not be the case, but those cases are hardly worth filing anymore. 2, establishing an early ESI protocol will help reduce cost and burden, protect you in the unlikely event that you accidentally disclose some privileged information, help you figure out what to do about your 2031-280A designations, and really give you a roadmap for how to do this so that you're not piecemealing it out as you go throughout the litigation and being responsive instead of being proactive. New section, the new Rule 26 analog 2016-090 provides a clear pathway, a potential clear pathway to further reducing costs, because in theory, there is no requirement. If you're just doing an initial dump, you can still do an initial dump under that section without having to identify your documents. It's not clear what happens downstream, but just make that part of your protocol. And last, I think, request the new $250 reportable sanction every time that you're filing a motion to compel on a request for production, inspection, sampling, etc. Because at the very least, you're going to get $250 more dollars. But if the judge is really offended by opposing parties' egregious conduct, the judge could make them report it. And I think that that's a lot more like a $10,000 sanction, frankly. And then the last one, when in doubt, right, partner with a ACEDS certified professional, whether it's an attorney like Mr. Evans, or a lit support professional like Joy, or somebody who's a little bit of both like me, but partner with somebody because they can help you get through all these issues and deal with them the right way from the beginning, so that you're not playing a lot of catch up, doing a lot of extra work downstream, trying to unring the bell, trying to fix your pile of spaghetti, all of those things that are nightmares for us that deal with this on a day-to-day basis. And with that, I wanted to ask Gareth and Joy if they had any other key takeaways.
You did. Only thing I want to say is to thank you, Grady, for the tremendous amount of work that you've put into this, in doing all the research and preparing all these slides and leading the presentation. I think you've done a fantastic job and greatly appreciate it. So thank you.
And I say ditto. And again, I just leave it to everyone on the call. This is such a great opportunity. We've seen this before. So don't think it's just going to pass and it really isn't anything. Take the time to, again, Grady did great research. There's a lot here. And there's a lot of things to start and jump off to keep a jumping point to go and just keep learning more and get your ACEDS.
Perfect. Well, since we're over and I think we've covered everything we want to, I think we can wrap, unless, and in fact, let's wrap and then answer the questions maybe after we kill the recording. What do you think?
Well, there's
It's
no
up to
other
you.
questions. We'll start with there's no other questions.
So that's perfect. Then we're all set. right? We answered everybody's questions. Thank you so much, Gareth and Joy, for joining us today, and Marla for all of your help throughout the conference and with the planning and everything. And on behalf of Marla and the San Diego Paralegal Association and everybody that's helped to put together this conference, thank you so much for joining us. We really want to try and do this in person next year. So if you happen to own an island resort and wanted to make that available to us, and or have a standing discount at maybe the Mission Bay Resort in San Diego or somewhere down there, we'd love to go down there. Reach out to me through DMs. And all three of us are on LinkedIn. Please come find us, reach out to us for any kind of help. Obviously, both Gareth and Joy are going to be able to help you professionally and could engage you in a business relationship. For me, you got to hire my firms first, but I'd be more than happy to help you once you become a client. So thanks again, everybody. Really appreciate everything. Have a great rest of your Saturday. Thanks for joining us. And without any further ado, we're done. Have a wonderful day. Thank you so much.